Assalamualaikum sir, this is Khalid Rahman. Now I start my presentation. My presentation topic is state territory. Now I talk about the concept of the territory in international law. International law is based on the concept of the state. The state is termed lies upon the foundation of sovereignty, which express internally the supremacy of the governmental institutions and externally the supremacy of the state as a legal person. In international law, to be state, there must be a government in effective control of territory. Territorial sovereignty covers all land, internal waters, territorial sea, and the airspace. Above them, a state does not have sovereignty over its continental self or the exclusive economic zone. Instead, it has sovereign rights over its continental self and certain sovereign rights and jurisdiction of economic EEZ. Most of the current international law on territory result from dispute between states as to ownership of land, but these days they tend to be more over land to maritime boundaries, and sometimes Island's territory is of course itself geographical conception relating to physical areas of the globe, but its centrality in law. International law in particular derives from the fact that it constitutes the tangible framework for the manifestations of the power by the accepted authorized of the state in question. Now talk about the evolution of territorial integrity. The concept of the territorial integrity emerged as a general principle of international law during the course of 19th century. In the middle of 19th century, the language on territorial protection that we still use today already established within the discourse on international law. In this 1844 treatise on European public international law, A.W. Hefter speaks of the territorial principle that grants a right to integrity of the inviolability of state. In the United Nations Charter, we now find the protection of territorial integrity specifically mentioned as a critical component of the prohibitions of the use of force as provided for in Article 2 all members Article 2 Section 4 all members shall refrain in the international relation from the threat of use of force against the territorial integrity of the political of any state or any other manner in consistence with the purpose of the United Nations. For a time, the 5th and the 16th centuries, the mere sign of the previously unknown territory may have been enough to give good title as a state, although even this is doubtful, but it soon became established that a symbolic act such the planting of a flag or a formal proclamation was also required to confirm title, and by the mid 16th century, discovery was seen as conferring no more than in short a title that need to be completed of effective occupation. In the past, conquest, sometimes it's called annexation. Sometimes called annexation was followed by annexations was a means of acquiring valid title to territory. Whether annexation now provides good title will therefore depend on the international law at the time. International principle whether the annexing state has established effective control over the territory, and whether the other state have recognized the annexation even in the period between the two world wars. It was not clear if a state could acquire good title by consequent and annexations. Thank you, sir. That's all my presentation.